you will have 15 minutes to present oral arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant in this case and wish to reserve time, please let me know when you get started. I'm keeping track of the time, and you can see the clocks on the wall. These arguments are being recorded. Please keep your voice up and remain behind the podium. Please do not use the names of any children or victims, as this will be posted on the court's YouTube channel. I know there's a cross appeal. However, the cross appellant needs to make, there's no time reserved for the cross appellant's rebuttal, so the entire 15 minutes at once. The judges have read the briefs. We're ready to see when you are.
Thank you very much. Good afternoon. May it please the court. My name is Leslie Kransky. I'm here on behalf of the appellant in this matter. This case started in 2013 when mother administered clonidine to the party's profoundly disabled child. The child had had episodes which were near-death experiences on several occasions. The nurses in the home started doing a pill count because they were thinking that was what was going on. And it turns out the mother had pills hidden all over the house. And so the pill count was difficult to achieve. CSB was called in, which is what it was in 2013, and removed the children. They were then placed almost immediately with father in his temporary custody. After a full-blown trial, father was granted legal custody and mother was given supervised visitation. And yes, I would like 5 minutes at the end.
Certainly.
Mom has asked for, mother was granted only highly supervised visitation at that point. She filed and obtained supervised visitation that is closely supervised but not at the location of common ground. So it's essentially the very same thing but a different location. But the court found that mother had never accepted responsibility for her actions, which caused the children to be involved with children's services in the first place. Mother has not treated for Munchausen's by proxy, which is now known as factitious disorder imposed on another. Her counselor came in and talked about how well she's doing, but she's not dealing with those issues.
Was she actually diagnosed with that?
You know what? That was the issue in the original appeal. You are correct. And the court, there was some conflict in the trial court about whether she had been fully diagnosed, but her conduct was commensurate with it according to the magistrate at that level in 2014. The trial court said it doesn't matter whether she's diagnosed, there's all these other things going on that are wrong, so I'm going to place the children in the legal custody of father. So we do not have an official diagnosis. But when it walks like a duck and it quacks like a duck, maybe we should look at whether it has feathers. And mother continually talks about the allegations against her. Well, they weren't allegations. The children were found to be neglected and, in the case of the disabled child, dependent, excuse me, and then the other one was considered to be neglected. I apologize for my stumble there. So now we move forward to 21, and mom would like to have a supervised time with the two children who are not disabled, and to have some contact with the disabled child. But she still hasn't done anything to accept responsibility for what she did that caused the disabled child to be in danger on so many occasions while he was in her care. She didn't show any changes in the children. She did not show any changes in the father or in his home. And according to the statute, that is the first prong before we get to anything else. She didn't show any changes, and certainly the court did not find any changes that would justify going to the second step, which is the best interest analysis.
What about the changes in the children's age?
There is,
Because now they could self-report.
well,
as
actually,
teenagers.
the guardian expressed that he was concerned about the girl in this family not being quite on the cusp of being able to self-report and take care of herself. But age in and of itself is not a change in circumstances. The court didn't say, oh, I find that the children are old enough now. But
Under Bratz, first Bratz, is a change of circumstance either required to change visitation as opposed to changing custody?
it does not. You know, you can have a change in circumstances and then you go through the statutory factors and you don't change the visitation or custody at all.
So your belief that Bratz does not apply and there has to be a change of circumstance to modify visitation?
I believe so, yes. I believe that this is within the scope of RAT. Only once you find that change of circumstances do we get to modification being necessary in the children's best interest. And the record is not supportive of that. The guardian testified that the girl was not only on the cusp of being able to self-report and take care of herself. Certainly, the disabled child has no ability to self-report. We don't really want to put the other children in the position of having to report for the disabled child. The interactions, while there was supervision from Common Ground, were good. The children were safe, and they could interact comfortably, and Mom was doing okay with that. But she had always been doing okay with that. And there's no reason not to continue letting her be okay with that in the circumstances of this case. The law of the case from 2019 firmly establishes that mother has never dealt with her responsibilities. She is in denial. She talks about allegations. She talks about understanding his concerns about the allegations, but she never said, I did something wrong and I need to be different about this. Although that wouldn't be the kind of change required under Bratz, it would at least give some justification for expanding her parenting time in this matter. That has not happened in this case. This court should reverse the addition of unsupervised parenting time for the older children and remand this matter to the trial court.
The most recent trial court order just seemed to me to not set a specific schedule for unsupervised visits, just said there'll be unsupervised visits. Is there a prior order that would help me understand what the visitation schedule is supposed to be?
Yes, I believe the 2009 order
Okay.
would tell you what it should be.
What would it be under those circumstances, the 2009 order?
I can't recall the exact details, but scheduling occurs through Common Ground.
Okay. So it still would be a few hours at this
It's a
point?
few hours every week, yes, that I can vouch for. And part of the thing that's troublesome with the companionship order in this case is there's not even a schedule. So these two people who, strangely enough, do not get along very well are being left to hang in the wind and
The
schedule.
2019 order doesn't give a schedule, it just simply says will be set by Common Ground, I take it then?
I can look it up and give you that answer when I come back.
But I would be looking to the 2019
You would be
order to
looking at
see
the
what that says.
2019
Okay.
order for that,
Thank
you
you.
know. But it's a certain number of hours, and in practice, it's been scheduled through Common Ground. I'm sorry, I can't give you something more
That's okay.
specific, but I'll look that up. So now to go to unsupervised with no schedule at all is clearly not in the best interests of these children. And we would ask that the court reverse that order granting unsupervised parenting time to the mother. Thank you.
Thank you, Counselor.
Good afternoon, Your Honors. Thank you. May it please the court, I'm Mark Karen. I'm here on behalf of the mother, and the mother is here in court today to observe these proceedings. And may it please the counsel, we meet you too. Just a couple of points I want to talk about to address what counsel for the father stated. First of all, part of this is about to become moot, because the oldest son will be turning 18 on June 20th of this year. So it may be moot as it pertains to him before this court gets a decision out. I don't know, but it will be moot when he turns 18.
And that would be the child that the court order, there'll be visitation, in essence, as the parties can agree, as I understood the trial court's order.
That, we're talking about the oldest son,
Right.
A.S.
Okay.
We're not supposed to use names, so
Right.
I just refer to him by his initials, AS. He was born June
Okay.
20th of 2005, so he'll hit 18 this summer. So this all may be moot as to him. But we still have the issues of the middle daughter, LIS.
And what is her age?
She was born in 2018, or I'm sorry, 2008. You're asking me to do math on the spot, which is
That's okay.
not much.
There's not math in this test, you're fine, thank you.
She'll still be a teenager. But with respect to the issue of unsupervised visitation for the daughter, I get counsel's concerns, I understand the father's concerns, but we're not here to relitigate what happened in 2013. It happened, it's been dealt with, it's been a cross that the mother has had to bear for the past 10 years now. But we're here to talk about, the snapshot in time is when the hearing was held in 2021 and where we are at now. The mother's treating counselor, Allison Phelan, testified that the mother has been doing absolutely everything she needs to do over the course of her counseling. No evidence to the contrary was presented to the lower court. The director at Common Ground, Mr. Derry, testified extensively at the hearing about how the mother acted entirely appropriate throughout all the supervised visitation was done with the two older children, found no concerns whatsoever about allowing unsupervised visitation with the two older children, and no evidence to the contrary was presented by the father. The guardian ad litem, whose name slips my mind, testified the same way, found no concerns about whether or not there should be unsupervised visitation. Again, no evidence to the contrary was presented. And we see absolutely no reason where the lower court lost its way in determining that after 10 years, she should be entitled to unsupervised visitation of her two children.
Do you believe the court had to find a change of circumstance to modify visitation at this point?
I think that the change of circumstances was set forth by the testimony of the three people who testified on this issue, Dr. Phelan, Mr. Derry, and the guardian ad litem, who testified.
But you would agree that a change of circumstance had to be found to modify visitation?
I believe it was found, at least implicitly in both the magistrate's recommendation and the lower court's order, when they recounted the testimony as to how mother had responded to the treatment over the past 10 years or so, and as to how she acted in an entirely appropriate manner during the course of the supervised visitations that were supervised by Common Ground and Mr. Derry's testimony about how all that went. I believe that is the change of circumstances, is that mother has dealt with the situation in an appropriate manner, and she has a tacit understanding as to why she got herself in that position in the first place, and she's dealt with it through her counseling and the testimony from the witnesses who observed how the supervised visitation went appears to corroborate that. I don't see how the lower court lost its way in saying let's give unsupervised visitation a try. We're dealing with the two older children, the one who's about to be mooted out when he turns 18. But there's nothing that indicates that there's going to be any threat to the middle daughter if the unsupervised visitation is allowed to occur. I want to talk about the mother's appeal on the issue of the youngest child, LUS, who does have very severe cognitive disabilities and is unable to communicate for himself. The father's primary argument in his brief regarding going from supervised visitation for unsupervised visitation for the two older children was that he wants a controlled environment where everything can be observed. That is exactly what would happen if supervised visitation was allowed for the youngest son. Every witness who testified, including the youngest son's case manager, said that there are steps that can be put into place, including having a nurse present, if there are any problems. There will be people who have no interest in the outcome of this case. They don't have a horse in this race that'll be watching everything. If that's good enough for the father to say that supervised visitation should continue for the older children, it should be good enough to allow those same to allow those same circumstances to dictate supervised visitation of the youngest child. And again, one thing that I thought was interesting in the court's disposition of this was that the court acknowledged that it would be better for the relationship to have supervised visitation of the youngest child, but the court did not want to force that on the father and left it up, elected to leave it to the father's whim, I guess, as to whether or not, any contact would happen. We know basically from the record what the father's position on all of that's going to be. That's a court's job to make sure that that happens, and it shouldn't be left to the whim of the father. If supervised visitation is good enough for the older children, give her a shot. She hasn't seen her youngest son in 8 years, something like that, other than occasional glimpses through a window. If something goes wrong, there are going to be people there who will spot it and who will correct it, and if it has to be revisited down the road, they will make sure that that happens. They all testify to
So you think the court's there with a not setting specific time for visitation with the youngest son, we'll call him, I guess, for our purposes?
Yeah, well, the court's error, in my mind, was leaving it up to the whim of the father. The court found no reason that there would be any harm or threat of harm or risk of harm to the youngest child. The court just didn't, I think as the guardian ad litem said, didn't want to force it on the father. And I think that the court adopted that, but I don't believe that that is proper for the court to say, well, it's up to the dad. Because we know the dad's not going to allow it.
LUS is close to being is a teenager as well. So he's a teenager as well, correct?
He was born in 2008. I'm sorry, 2007.
Right. So at the age
You're asking me to do
at
math,
the
I
age
guess.
of majority, I would suppose that dad would become his guardian.
I don't know, that's looking into the future. He's
And he is-
certainly not in a position where he can take care of himself. There's going to need to be guardianship.
And if he was the guardian, he would have absolute say over who sees his ward, correct?
I don't know how that works. I don't know how, I've never done guardianship work before. I don't know how that works. But
So sometime soon, he could be in a position, do you think he could be in a position where it is gonna be his decision if he was the guardian?
I would hope that it would not come to that, but I don't see the father being cooperative with the mother at all. As the counsel said, they don't like each other. And, that is what it is. We can't force that on them. But, again, there was no finding in the trial court, the lower court, that there would be any threat of harm, risk of harm to the youngest son if supervised visitation was allowed. It would presumably be done under the same circumstances the supervised visitation was done for the older children. There would be people present monitoring what's going on. The mother deserves a chance. She deserves a chance to get to know her youngest son. And God forbid if something happens, there will be people there who will be able to make sure that the child is safe. And with that, I will rest and ask that the court affirm on the order of unsupervised visitation for the older children and reverse as the denial of supervised visitation for the youngest son. Thank you all.
Let me ask you the same question I asked Attorney Grasky, and that is, as far as the older two children, and the one I appreciate is almost 18, would we go back to the 2019 order in the record to determine what the hours of those unsupervised visits would be that were issued by the trial court? Because I read the 2021 order, just says there'll be unsupervised visits, didn't set up a schedule or anything like that. So do you agree we'd go back to that previous order for?
I think that would be the appropriate starting point. I don't have the 2019 order ingrained in my brain, but that would be the starting point, and hopefully that they would be able to work it out. If not, that's what the court would be required to call upon. I know there's been some issues with the father complying with the order that's in effect with regards to unsupervised visitation, but those haven't been resolved.
Do you think the order is written as far as the youngest son that father could be held in contempt if he did not permit any visitation?
I would agree if the court ordered supervised visitation of the youngest child.
As it sits now, that it's at the discretion of father. Father just said, I'm not going to let her see her son, period. Would you think that would be punishable by contempt?
Sure. Thank you all.
As I was able, because I had my computer, to look up the 2016 and 2019 orders. I wasn't counsel in those cases, they don't stick in my brain the same as when I was in there all along. They both reference supervised visitation through, one of them is through an appropriate agency and the other is through Common Ground. And that's a typical juvenile court order because they're not going to tie Common Ground down to a specific amount of time and a specific date. So we certainly need some help on a schedule of whatever parenting time there is going to be for the two children who are not disabled. We continue to feel that there was no change in circumstances shown as to father that would justify changing the parenting time schedule at all, but specifically as to the disabled child, there's no reason to make this second move. Mother does behave in supervised parenting time, she really does, and that's why we want to continue this, so that children can have a good experience with their mother without the risk of what could happen if she is not supervised. For this reason, we would ask that the trial court reverse the decision as to unsupervised parenting time with the non-disabled children and to grant only and direct the trial court to grant only supervised time with the disabled child. Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which is mailed to all parties, as well as posted on the Ohio Supreme Court website. Our next